This is Earl White, real estate attorney. This is a video about 5 differences between commercial real estate contracts and residential real estate contracts. Very important for any loan officer, realtor, buyer, seller of commercial property, if they have a history of doing residential, to know what the key differences here to look out for when you're negotiating these contracts. The first key difference between commercial and residential real estate contracts is the importance and requirement of what is called a tenant estoppel statement. A tenant estoppel statement is a document signed by the tenant that lists the main terms of the lease, the rent, the term, any common area maintenance payments, utility responsibilities, options to renew, and it also attaches a copy of the most recent lease and any addendums there too, verified by the tenant, as opposed to just the seller. Now, the seller may give the documents in the beginning, give a rent roll at the beginning, but it's important for the buyer to have independent verification from the seller because, in theory, a seller has motivation to overstate the value of the property in the sense of additional rents. And also the buyer wants to verify there's no legal dispute between the tenant and the landlord, and the tenant is the best person. So adding that to the contract obligation may make them nervous about whether or not they can fulfill that if the tenants give a hard time. But tenant estoppel statements, more common and critical for commercial transactions, for commercial tenants, particularly prime tenants in any commercial building. A second key difference between commercial real estate contracts and residential real estate contracts is that the due diligence on a commercial real estate contract is much more detailed, thorough, and open-ended than a residential transaction. For example, in a commercial transaction, as opposed to just doing a physical inspection of the property at a basic level, you'll often have an environmental assessment done, which could involve interviewing neighbors. It could involve looking at city and state records, an entire environmental assessment done for the property. That is not going to happen for a residential real estate transaction. Also, for due diligence and commercial transactions, it may not even be limited just to physical inspections or records regarding physical inspections. Oftentimes, it is going to include review of leases. It will include review of certified income statements from the seller that maybe they're not, and maybe you don't have exactly from the beginning, but then they're produced during the due diligence period. It may also include verification of the terms of the tenant's leases, in the sense that the seller will have given an initial lease, but then there may be follow-up questions that need to happen with the tenant. And that will all happen during due diligence in many commercial real estate transactions. A third difference between commercial real estate contracts and residential real estate contracts is how the financing contingency may be structured. So residential is pretty straightforward. You have a mortgage amount, you have a time period to apply for it, and you get approved or denied. The terms are fixed. So very rarely are you going to specify in a residential mortgage contingency that a buyer can just cancel if the terms are not acceptable. For a commercial financing contingency, you may not even have one, right? It may just be baked into due diligence. For some contracts, 30 days, address your inspections, address your mortgage, and let us know moving forward or not. But if you do have a financing contingency in a commercial real estate contract, it's much more likely to be open-ended and for the buyer to cancel if they cannot get approval of a mortgage that makes sense for them. And the reason is that for the financing contingency, commercial loans are not standard. There are a lot of factors that are going to be different. For example, interest rates may vary wildly a lender, as opposed to just being a standard one that anyone can look up in a residential transaction. There also may be additional considerations such as prepayment penalties for the loan, which on residential, by law, that's not even allowed, but for commercial, it's very common. And there may also be rules and regulations about how the buyer can use the property. And residential, there are rules about who needs to own or occupy it, but they're going to be much more standard process on a residential mortgage than there is on a commercial mortgage. So the buyer for a commercial side would want a more open-ended mortgage contingency to make sure they're not just getting approved, but they're getting approved on terms that make sense for the buyer. Obviously, seller might want to narrow that, but the truth is a buyer cannot predict very well what the terms of their mortgage will be in terms of the fine print in advance. And so the open-ended contingency makes sense for a commercial contract. A fourth important difference between commercial and residential real estate contracts is assignment or leases and rents. So what an assignment of leases and rents is that it's a document executed by the seller and the buyer at the closing that specifies that any tenant deposits and the right to collect. So any tenant deposits are going to go to the buyer. All rent collection rights are going to go to the buyer, and all the leases that are with the tenants are going to be formally assigned to the buyer. And that's important because the buyer is now the owner and collecting the rent. So obviously we want it very well documented that the leases are being signed. And if you don't have those documents, it could be implied that the new buyer is taking over the rents, but it's not in writing if you don't have those specific documents. So you need those in place. Residential properties, occasionally you may have a document like this for that. But generally, if you're buying it vacant, if it's owner occupied, you're not going to need these documents. And even if you do, you probably can get away with much simpler versions than the versions you would need for a commercial real estate contract. The fifth difference that's extremely important for the parties to be aware of when you are involved in a commercial residential transaction and contract as compared to a residential contract is the use of a permission in the contract to use newly formed special purpose entities for acquiring ownership of the property. Generally for residential, that's not relevant. The person who's on the contract is going to be the buyer at the closing, and even for basic investment properties. But when we're talking about a commercial real estate transaction, there is almost always going to be, I mean, not always, but the larger the deal, it's going to normally be a new entity that is formed to take title at the closing. And that's very important for liability reasons. If you have an LLC that's on the contract, that may be an operating company that's going to be supplying the funds. You would not want that entity to take control of a commercial building that may have lawsuits, legal issues, problems with tenants, which would then open up the parent company, the operating company, to liability should there be lawsuits or disputes. Put it in a special purpose entity, newly formed, limited to this property, then tenants are going to have less ability to go after the parent company to obtain funds or penalties, and will be limited to accessing the funds of the newly formed entity, which will be much smaller and create a much better liability circumstance for the buyer after the closing once they take title. You would also want in this scenario to have the contract provision laid out in detail that allows for this. The seller may consent in the future, but you would want to set forth the terms for which the assignment can go forward. Buyer, you just want something simple. Buyer may take title and seller may execute any addendums necessary to accomplish this at the closing for the new buyer to take ownership in their entity. On the seller side, you may want to narrow that whatever the entity is created is predominantly owned by who the initial seller was. And you probably also want to specify that the original contract buyer and the new buyer being proposed are both fully, jointly and severally responsible for all the contract conditions. So the buyer couldn't try to wiggle out of liability once an assignment document is transferred at the last minute. So you want to make sure you reserve your rights against the original buyer, the new buyer, to avoid the buyer having a way to exit the contract and leave the seller with limited recourse against a newly formed entity that does not have substantial assets to go after in the event of a breach of contract.